Hi friends, in this video we are going to deal with the article titled Fundamental Rights, Right to Freedom, Article 22. To know more about it, let's quickly move on to the topic.
Hello everyone, in this session I'll be dealing with Article 22. So let's start with the discussion. Article 22 states that protection against arrest. Article 21 and 22 complement each other. For the larger interest of the public and maintaining rule of law, there is a need to restrain some people's right, but on sound grounds. Now Article 22 grants protection to persons who are arrested or detained. This article comes into play after arrest or detention and not before that. Detention is of two types. Number one is punitive detention and number two is preventive detention. So punitive detention is to punish a person for an offence committed by him after trial and conviction in the court. And preventive detention means detention of a person without the trial and conviction by the court. Its purpose is not to punish a person for a past offence but to prevent him from committing offence in the near future. Preventive detention is only a precautionary measure as based on suspicion. Article 22 has two parts. The first part deals with the cases of ordinary law and the second part deals with the cases of preventive detention law. Punitive detention is done in any ordinary law, whereas preventive detention is done in preventive detention laws only. Article 22, Clause 1. Arrests, I will be telling you about it now in detail. Arrest means, arrest is legal and technical word, which means to restrain. All rights of arrested person shall be confined and he shall be put into the custody of law. This clause of Article 22 provides two rights. Number one is right to be informed about the grounds of arrest, which in which at the time of arrest a detained person has the right to know on which ground he is being arrested so that he can defend himself and prepare for trial or apply for bail. So there was a case which was named Joginder Kumar versus State of Uttar Pradesh, and in this case it was held that a detained person should know the cause of his detention and is entitled to let any third person know the location of his detention. Now, second point is right. The second right is right to consult and be defended by a legal practitioner. In this, police cannot deny an arrested person to consult or meet the legal practitioner of their choice. There is a very famous case in this point, and it is of Husainara Khatun versus Home Secretariat of Bihar. The case is of 1979. You can note it down. And in this case, the Honorable Supreme Court held that if accused cannot afford a legal practitioner, then he has the right to demand a free legal practitioner from the state. Now, the essence of this case can also be observed in Article 21. So we can see the essence in that article also. Now, Article 22, Clause 2, this part provides two rights. Number one is right to be produced before a magistrate within 24 hours excluding the journey time, and number second is right to be released after 24 hours unless the magistrate authorizes further detention. So once that period of 24 hours finishes, you have to it is the right of the arrested person or the detained person that he shall be released. Now Article 22 Clause 3. It talks about exceptions in provisions of punitive detention. So these safeguards are not available to an enemy alien or a person arrested or detained under the preventive detention law. Now, the Supreme Court also ruled that the arrest and detention in the first part of Article 22 do not cover arrest under the orders of the court, civil arrest, arrest on failure to pay the income tax, and deportation of an alien. So this Article 22, it does not apply to these things. Now they apply only to the act of a criminal or quasi-criminal nature or some activity prejudicial to the public interest. So this is where it applies. Now Clause 3, Subclass B, it says that if any person detained under the Preventive Detention Act, then they cannot enjoy protection given under Clause 1 and Clause 2 of Article 22. Now let's talk about preventive detention for a while. Now this protection is available to both the citizens as well as the aliens. Now Article 22 Clause 4 explains in it 2 points. 2 points are explained there. Number 1 is the detention of a person cannot exceed 2 months. The advisory board can increase detention time after sufficient proof up to the described as it is described in the law. So the advisory board consists of the High Court judge or a person qualified to become a High Court judge. Now second point is that a detained person shall be given an opportunity to make a representation against the detention order. So this is all what clause 4 states in Article 22. Now let's talk about clause 5. So Article 22 clause 5 it states that as rights given under clause 1 of punitive detention, those same rights are given in clause 5 of preventive detention. They both are exactly same. So point number 1, it is the right to be informed, okay, which means it is the duty of the police to inform the person who is detained. Number 2 is right of representation. This right is of the state, that he has to be represented. So this is all in clause 5. These are very small clauses, so you don't need to go through them in detail, but just superficially go through them. So Article 20. Now let's go to clause 6 of Article 22. So clause 6 it states that if the authority finds any information disclosed is against the public interest, then such information will not be furnished to the accused. It's very simple. You do not have to get into the detail for this. Now let's get to the next clause, which is Article 22 clause 7. So this clause gives power to the Parliament to make laws, mention the procedure of advisory board, inquiry, and define the detention time. So clause 7 does this. Now let's talk about power, who has this power to make preventive detention laws. The Constitution has divided the legislative power with regard to preventive detention between the Parliament and the state legislatures. Both the centre and the state legislature can make laws on this topic. The Parliament has exclusive authority to make law under the 7th schedule, that is the central list for defence, security and foreign affairs. And state legislatures can make laws with the Parliament concurrently under 7th schedule of the concurrent list for public order and maintenance of supplies, security of the state and services essential to the community. So now here is a list of I'll be telling you some preventive detention laws. So I've made a list of them, so you can note it down. Number 1 is Preventive Detention Act of 1950. Number 2 is Maintenance of Internal Security Act 1971. Number 3 is Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. Number 4 is National Security Act 1980. And number 5 is Prevention of Terrorism Act 2022. So let's get further. The 44th Amendment Act of 1978 has reduced the period of detention without obtaining the opinion of the advisory board from 3 to 2 months. So this time has been reduced. Now, however, this provision has not yet been brought into force, hence the original period of 3 months still continues. Now, let's discuss some very important case laws of this article. So, number 1 is DK Basu versus State of West Bengal. It is a very leading case also, and you might have heard about this case multiple times. So yeah, this case of DK Basu versus State of West Bengal is one of the landmark authorities which enumerates guidelines and requirements for arrest and detention provided by the Supreme Court. So there are 11 guidelines which are an addition to the constitutional and statutory safeguards, and they do not contradict these 11 guidelines. They do not contradict with these statutory safeguards that are provided. So the memorandum focuses on maintaining proper and authenticated records from the side of authority known as inspection memo. Now next case is of A.K. Roy versus Union of India. This case is of 1982. In this case, the court acknowledged that the preventive detention laws were not only subject to Article 22 but were also open to scrutiny under Articles 14, 19 and 21. So there is a very recent case, like it's from 2020. It is of Ankit Ashok Jalan versus Union of India. You can note it down. This is very important and this is very recent also. So you can put it in this topic of preventive detention. Now the case is of, I'll say that again. It is of Ankit Ashok Jalan versus Union of India, 2020. In this case, the court held that and state government is not bound to wait on the advisory board's report before deciding the representation and must do so as expeditiously as possible. Now, next and last, we have a very recent case which is of 2021. It is Sarabjit Singh Mokha versus District Magistrate of Jabalpur. Now, it was held in this case that the delay by the state government in disposing of the representation and by the central and state government in communicating such rejection strikes at the heart of the procedural rights and guarantees which are granted to the detained person. It is necessary to understand that the law provides for such procedural safeguards to balance the wide powers granted to the executive under the NSA, that is the National Security Act of, like I mentioned it before also, this act is of 1980. So that's it for today. I hope you find this video helpful. Thank you.